Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and the quality of life that she's accustomed to. That is still need.
Witnesses, what motions were those for?
We disclosed we had an income analysis done of Mr. Yost, Your Honor. That was disclosed on January 17th through Jeff Querin. So the only part of the motion that we have dealt with that obviously is the motion to modify spousal maintenance. If the court would recall, initially when we filed this case, we're the petitioner, we had set spousal maintenance at $9,000 a month. And the court actually called me, this would have been through the ex parte temporary order, inquiring as to when the last year of tax returns we would have had available at that time, and that was 2018, which Mr. Yost at that time had made significantly less than what he had made over the last 3 years that we've averaged. So at the time, maintenance has been set based off of an income of Mr. Yost around $338,000, $318,000 or somewhat. And the report we've had from this income analysis that Jeff Querin has done 7 weeks ago has his income average over the last 3 years at $664,000. So
this is a huge moment in the case. The petitioner's attorney just presented evidence that Mr. Yost's income has nearly doubled in recent years, averaging $664,000 annually compared to $318,000 in earlier tax returns. That's not pocket change, that's life-changing money. Now here's the catch. Spousal support in most states considers not just what the spouse needs, but also what the other spouse can pay. And when one side can show this kind of financial growth, it puts serious pressure on the court to reevaluate the original support order. But here's the question. Should spousal support really adjust upward just because someone starts earning more? Or should it only cover reasonable documented expenses?
Again, that's not brand new news. Again, that report was issued and sent to Mr. Thompson within a couple of days, if not on January 17th. So, I mean, there's been ample time to respond to that. Frankly, if we're disclosing expert reports by statute, Mr. Thompson would have had to have a responsive expert opinion within 30 days of receiving notice of us issuing that report. So that's not been done, and we're outside the 30-day window. So I really don't know what the dispute is on this motion with respect to the spousal maintenance, besides trying to continue to delay this matter. So again, we're ready to proceed. It's all argument. There's not any need besides the domestic relations affidavit or sworn statement. There shouldn't be any need to question anybody on the witness stand. This can be done through argument.
Your Honor, and I disagree completely. If we review Ms. Yost's domestic relations affidavit, every single expense that she listed, she deems as estimated. Every expense without a single exception.
Now we see the defense strategy. Attack the credibility of the expenses. Every single cost submitted by the petitioner is marked as an estimate. Rent, estimate. Food, estimate. Even attorney's fees. Again, just an estimate. The defense is driving home the point that without actual receipts or records, the court has nothing concrete to base a ruling on. And this is a brilliant tactic, because while income can be proven with pay stubs and tax returns, lifestyle needs can be a much fuzzier concept. Viewers, what do you think? Should courts accept estimates in cases like this, or should the requesting spouse always have to provide hard evidence?
That she deems as estimated. Every expense without a single exception. As the expert report, if I have a reply to their expert report pursuant to the rules of civil procedure, that's 30 days. I can have an independent expert, separate and apart, Your Honor. I have a demonstrative exhibit, which I anticipate. Let me try to be as succinct as I can. We cannot get this done in 45 minutes. Any one of these motions, Your Honor. Any one. The domestic relations affidavit is riddled with, well, they're all estimates. I'm entitled to inquire of Ms. Yost as to what her actual expenses are, because she has not provided a single solitary actual expense to justify any deviation from the court's order of spousal support. None, Your Honor. Everyone's an estimate. And the court cannot make a determination based on pure estimates by the party requesting a modification of her own spousal support award.
But there's no case law to discuss that, Your Honor. Estimates are commonly used because a DRA has to be filed prior to the time of trial. Usually most pretrial conference orders require 10 days in advance of trial or 30 days, depending on the court and jurisdiction you're in. At that point in time, It is very common practice to have the exact amounts put in. Otherwise, you put estimates in. That is something I've commonly done in 15 plus years of domestic practice. And frankly, if we're talking about my client's expenses and we want to get into the analysis on spousal maintenance, it really doesn't matter because need doesn't have to show. Of course, we're talking about need versus ability to pay. Clearly, there's an ability to pay. But when we start talking about need, it doesn't matter if my client.
Listen to this legal argument carefully. The petitioner's attorney is claiming that need isn't about survival. It's about maintaining the lifestyle the spouse is accustomed to. That's a powerful point because spousal support isn't only about food and shelter. It's about fairness. If you lived a luxury life during the marriage, should divorce mean a sudden downgrade? The law often says no, but that raises another question. Where do we draw the line between legitimate lifestyle support and outright entitlement? This tension is at the heart of so many spousal maintenance battles, and today's case puts it under a spotlight.
Is destitute or has to live or needs the exact amount of money she's requesting by spousal maintenance. It is need is a standard of living. Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need. And that's what we're dealing with here. Again, there's been ample time for Mr. Thompson to respond to Dr. Querin's report from January 17th that we provided to him. We are ready to proceed. This has been set on the court's calendar for a number of weeks. We need to get moving on this immediately. There's no reason to have a half day or a day long hearing over motions to modify a temporary order. It's not that complicated.
I'm sorry. And Your Honor, I'm astounded Mr. Olson made the argument that need is not a factor. Need is most certainly a determinative factor as to spousal support. And the court cannot make a decision when every, not just one or two, every expense is estimated. And it is not for the time of trial. She is asking for a change right now. So the need right now is what we need to determine, not what she may think she needs in a year or two, which I don't even know where she's coming up with these numbers, Your Honor. Most certainly $4,000 a month in attorney's fees.
The defense just threw a grenade into the courtroom. $4,000 a month in attorney's fees. That's nearly $50,000 a year just for lawyers. And they're framing it as proof that the petitioner's numbers are wildly inflated. Think about that. If she's spending that much on legal representation every month, what does that say about her financial planning? Is this a legitimate expense tied to the divorce, or is it a tactic to pressure Mr. Yost into paying more? The judge has to decide whether these costs reflect need or just strategy. Would you call this a reasonable legal expense, or is it pushing the limits?
For every month. But, Your Honor, we're putting the cart before the horse. I didn't say a day. I think it can be done in half a day. The court does not have the ability. I don't think the court has the ability to make an informed decision based upon argument when there are all of these issues and all of these issues with the documents that have been submitted. We have over 300 pages of exhibits, Your Honor, for a status conference. That is not status conference material, Your Honor. That's a half day in person, as this court's procedure has been throughout this case and the other cases I've been involved with, Your Honor.
All right, if you all can give me just, I'm going to take a short recess to review these docket notes. Give me just a second.
And there it is. The judge calls a recess. Why? Because the paperwork is overwhelming. Over 300 pages of exhibits have been filed for what was supposed to be a status conference. That's right. A simple check-in ballooned into a legal mountain of reports, affidavits, and motions. This highlights a truth about family court. When money and pride collide, cases can spiral into endless documents and delays. Judges hate this because it clogs the system. But for attorneys, dragging things out can sometimes be a strategy in itself. Do you think this level of paperwork is justified, or is it just legal theater?
All right, we'll go back on the record, same appearances as before. All right, going back through the docket notes. January 14th was the last time we were here. The parties were still exchanging exhibits. I don't think at that time any of these new motions had been filed yet. I think those were, it's January 29th, the date that those were filed. So we set it for February the 10th for a status by Zoom at 3 o'clock. We got the notice about your mom, Mr. Thompson. Sorry to hear about your mother. It was continued for very good reason. Again, for status. So typically when motions are filed in between, when we've already got a status hearing filed, I take that as an opportunity to determine, have any of these motions been resolved? Do we still need more time to get documents? I typically don't utilize that as a time to hear those motions unless it's something minor that we can get addressed. So in my mind, I tend to believe with Mr. Thompson here that this just needs to be set so we can hash everything out. Frankly, a lot of reading through these motions, I thought a lot of this stuff would have been resolved already. I mean, these are the types of issues that aren't ones that we typically have to spend so much time trying to resolve, just the exchanging information, making some concessions to help one party get along during the pendency of the case. This case is getting long in the tooth. Where are we at on domestic conciliation?
The judge's frustration is crystal clear. These are issues that should have been settled through negotiation, not argued over in marathon hearings. He even points out that the case is getting long in the tooth, meaning it's dragging on far too long. And here's the bigger picture. Every delay, every new motion, every status conference costs both sides more time, more energy, and more money. For the judge, this isn't just about the Yosts. It's about keeping the entire docket moving. For the parties, though, every delay could be a deliberate tactic to exhaust the other side. Divorce court isn't always about justice. It's often about endurance.
Parties are in with Richard Samanago. They've got another follow-up appointment. I think they've met with him twice. Got another one in another week. They're still in the mediation phase. It's clearly going to go to an investigation aspect for DC. So I can follow up with Richard this week. We had kind of planned to do that anyway, but I would anticipate probably at least another 3 or 4 weeks before we have anything as far as feedback from him.
All right. I understand, Mr. Olson, you're wanting to get this stuff resolved. I want to get cases resolved probably more than you guys do. But this is a status, and this is what we're doing. We figure out, has anything been resolved? What do we need to do? Well, it doesn't sound like anything's been resolved, that we just need to set everything for hearing. But I want to set an afternoon, and it'll be an in-person hearing. And we'll take up everything that we can that has not been resolved at this hearing.
Your Honor, may we try to set something within 2 to 3 weeks, and literally whatever I need to do to make a time work, I will make that happen. And I've actually got some good availability in the next 3 weeks for things. I mean, it's just something needs to get moving on this for my client's benefit. So I would greatly request that we be able to have something set at least within 2 to 3 weeks.
Well, I know I've got spring break coming up, not next week, but the week after that. I think I've got a criminal docket week, so I don't know if I can do it that soon, Mr. Olson. Angela, when do we have a half day?
Not until April 30th at 1:15.
April 30th at 1:15.
That works for me.
So here's where things stand. The judge has set a firm in-person hearing for April 30th. That means both sides will finally have to put their evidence on the table and let the court decide once and for all what spousal maintenance should look like. On one side, we have a spouse insisting she needs up to $9,000 a month to maintain her standard of living. On the other, a defense hammering away at inflated estimates and questionable expenses. The judge's eventual ruling could set a powerful precedent about lifestyle support versus actual financial need. Now we want to hear from you. If you were the judge, would you grant $9,000 a month or push for something lower? Drop your thoughts in the comments below. And if you found this breakdown as fascinating as we did, don't forget, hit that like button, share this video with friends, and of course, subscribe for more jaw-dropping courtroom commentary. You won't want to miss what happens when this case returns to court.